thank you to everyone for joining us today on this webinar. We're going to be speaking on with our panel of attorneys with some guidance to avoid payment problems in California. Again, thank you all for coming. We're so excited that you are here. First, we're going to introduce today's moderator, and Mr. Seth Bloom, take it away.
Thanks, Kara. I really appreciate it. And thank you for everyone that came out today. This is really exciting. We did a similar webinar to this just a few weeks ago, and there was tons of California questions. So we knew we had to get those answers. So we brought on two great California lawyers today, and I'd like to introduce them. Kara, if you want to change. Why don't we put the lawyer bios on?
Yeah, my apologies. Technical difficulty on my end. There we go.
Okay, here we go. Today's panelists, and they're not too far away from each other. It's Peter Ryan at Flores Ryan. He's a construction attorney out of Pasadena, and Peter Lindberg at Lindberg and Mazer in Glendale. So they're neighbors. Yeah. So I really appreciate both of you coming on today and doing this webinar and helping our customers solve some of the questions behind construction payment in California. So let's take it away and get started with the webinar.
Sounds good, Seth.
Great. Okay, roundtable topics. Why getting paid is such an issue in the construction industry. Number two, proactive steps to contractors take to avoid payment problems. And three, success stories of construction companies that have kept non-payment issues at bay. So do we want to start tackling those, Kara, one by one with each attorney? Okay, let's do that. Well, I would say Peter, but which Pete wants to start?
Sure, I'll start. This is Peter Ryan here. Thanks everybody for coming today. So our first question here, why is getting paid such an issue? I think it really depends on the project, the primary reasons that payment becomes an issue. I think on large projects, especially for the smaller players, subcontractors, material suppliers, that getting paid is an issue because the multiple levels of bureaucracy and administration above those people, and also when there tends to be disputes between the general contractor and the owner, everybody else gets caught up in those disputes, whether or not they did anything but perform their work. With respect to smaller projects, what I see is the primary issue is basically everybody just trying to protect their business interests and their cash flow. I mean, obviously the name of the game in construction or any business is to collect what you can collect and then pay out what you need to pay after. Everybody's trying to meet that goal. And in that fight, there ends up being friction where getting paid ends up being a problem, even if you're performing what you agreed to perform.
Yeah, Peter is absolutely right. And you combine that with the kind of the inherent nature of the beast. I mean, construction is a credit industry. And at least on the typical project, quote unquote, if everything works right, you mobilize on day one, send in your first invoice on day 30. And if you're really, really lucky, you get paid on day 60. So you're 60 days into this before you see dime one. And as everybody knows, you make your profit on the back end of the project. Anybody who's in this business is, whether you know it or not, a lender.
I'm not on mute. I also just I forgot to mention before, if anyone has any questions, please post them in the chat or ask a question, and we'll get our lawyers to answer them live, or we can wait till the end. We'll have some Q&A time as well. All right. Should we go to the next slide?
Yeah, let's go to the next one.
So let's talk about some general steps to take to avoid payment problems.
From our point of view, the big steps are the planning that everybody does up front. I mean, you plan a project before you hit a project. You don't show up on day one and say, gosh, what am I going to do now? you've thought about how you're going to execute the project before you show up. Well, you need to do the same thing on the administrative end. One of the things you need to do is think about what your contract documents provide. Okay, we have more than one client for whom we've drafted various form contracts for various situations. Am I uphill? Am I downhill? Am I the prime? Am I a sub? Et cetera, et cetera, et cetera. And when they're required to start with somebody else's form, and sometimes you are, a lot of the times you are, they send it to us for a quick review. I mean, that's the kind of stuff that the big boys do in-house, but most people don't have in-house legal departments. So you kind of have that routine. The second routine is, what are you doing on your administrative back end, your accounts receivable folks? Do you have a routine set up where they send out the 20-day prelims as a matter of course? Do you have somebody monitoring payments for aging? Do you have a procedure in place for asserting your job rights as well as your contract rights? Things of that nature. We understand, and both Peter and I are in this business and serve this industry, so we're fortunate enough to be able to understand a lot of what's going on here. We understand you guys all like to build things, and we understand that you guys all hate paperwork. But paperwork is unfortunately a lot of the times what gets you paid in this business. So you gotta have somebody paying attention to the administrative side, because that's a lot of times where you fall down.
Yeah, I would agree 100% with Peter. Clear contractual provisions when you're providing the contract, and understanding the contract even if you don't provide it, and making sure you follow those provisions, whatever the deal is, to secure payment, whatever the payment applications require. Following that, I think, is one of the first steps to make sure that there's not going to be a dispute. And then, the next thing, as far as your accounts receivable, making sure that if payment isn't coming as expected, you are following up as soon as payment becomes overdue. So you're aware if there is a problem, you're aware as soon as possible. And another problem that I see a lot of contractors, when things get more contentious, they're tempted to, especially if they're still on the job, be tempted to withhold their work or do something like that to use that as leverage to get paid. But a lot of times the contract doesn't allow for that, and that can create liability in of itself. So it actually creates a defense to payment instead of achieving what they're trying to achieve, which is to get paid. So understanding the contract and what your rights are, what kind of leverage you can assert and what you shouldn't assert, what's going to cause you more problems than serve to use as leverage is important. And then I guess the other thing is, you want to be cooperative with your customer. And if they're having issues with whoever's above them, they're saying they're waiting on the owner to get paid, that's fine. But you want to trust them, cooperate, but you also want to be sure to protect your rights. So they may say, yeah, the owner's still hasn't paid us. That's why we haven't paid you. But that doesn't mean that you should sit back and just take their word for it. You should still do what you need to do as far as, first of all, preliminary notice initially. And after that, any lien demands or to the extent you need to record a stop payment notice or make a claim, everything that you need to do to protect your rights, you should do. And that doesn't necessarily mean that you're being unreasonable or aggressive. And you just have to frame it as, hey, I need to protect my rights. I understand you're having issues getting paid. We all need to get paid, but I'm going to do everything I can to protect my right to payment all the way through. So that way, when everything falls into place and somebody needs to be paid, if they're making choices, who are they going to pay? They're going to pay the person that has done everything to protect their rights. That is they see as the biggest problem first. So that's going to get you paid first.
Yeah, Peter is absolutely right, and we have the fortune of being out here in Hollywood, and the greatest line in American cinematic history is, "It's not personal, it's just business." Okay, so don't be bashful about saying, "I have to do this because I'm not getting paid." People will understand that. In that line, there have been a recent development in California law in the last couple of years. A couple of cases have come out which have limited the applicability of what we used to call a pay when paid provision. In the old days, construction contracts typically said that me receiving payment from my uphill party is an absolute precondition to me having to pay you. Those things got voided out about 25 years ago. Then we went to a fairly expansive pay when paid, which was the standard in California for a long time, that basically said, "I will pay you within a reasonable time, but if I have to chase the guy uphill for the next 3 years in order to get payment, that's a reasonable time." That is what has been voided out in the last couple of years in a couple of cases. So you need to, when you're negotiating payment provisions, those old forms are going the way of the buffalo here. And you need to, maybe for the first time in 25 years, actually really pay attention to what your payment provisions in the contract say. Those were things that people just used to glaze over. So that's the newest safety tip here.
I know we have a quiet room right now, so I'll ask a quick question, but I mean, are there any like red flags or just any sort of patterns that both of you attorneys see on a regular basis when it looks like things are going downhill, or maybe some things that our customers out there should look out for?
Peter, you want to start?
Yeah, sure. So, I mean, I guess the biggest red flag that I see is, especially on a project that has multiple subcontractors, it's usually not just one person that's not being paid. There ends up being payment disputes among a bunch of people, and one of the best things to do, usually you're not going to be the first one. So, I mean, talking to other people on the project, what's going on, are there issues, and kind of just keeping your antenna up, keeping your radar on, can be an effective way to get out ahead of it, in front of an issue. If there's something developing, maybe there's a dispute brewing between the general contractor and the owner. If you're aware of that sooner, you can be a little more aggressive in asserting your rights and protecting your rights, and potentially, if you need to, get an attorney to help you do everything you can if there's a major issue brewing.
Yeah, and that's where asserting your job rights actually gives you kind of a voice. I mean, those of you that are subs and suppliers very seldom get to talk directly to the owner, or if you're on a private job, the construction lender. But if you send in a stop payment notice to that construction lender, or you send in a stop payment notice to the owner, you're going to get a phone call, and then you're going to get it directly from the horse's mouth as to what's going on the top side of the project that you never see because you're down in the weeds doing the work.
I have a question for y'all. Would you say that, having an attorney that understands your business before a problem happens would be beneficial to you in keeping up with contract reviews and other things that might benefit them in the future when a problem does arise?
Yeah, I mean, I would say that that's certainly the case. The biggest advantage that I have with existing clients is, one, if it's their contract, I already know the contract. I know what their rights are on the contract. I know what the obligations are. So if we need to take steps to address an issue, we can do so right away, and we can do it quickly. And we know where basically where the cards are, where things lie already. And we've set up things strategically to protect rights. Whereas if you get somebody new, especially if it's an urgent situation, there's payment deadlines looming, it can be a very tough situation, and you can lose leverage, lose rights, and perhaps not resolve a dispute that should have been resolved because you're behind the ball.
Sure. And the other thing is just dealing with somebody who has a knowledge of the industry generally. I mean, we take a certain amount of pride around here in representing all facets of the industry, big public and private owners, general contractors, subcontractors, material suppliers, sureties, et cetera, et cetera. And one of the things that gives us is the advantage of understanding where the other side of the table is coming from. Why? Because we've been on the other side of the table. So that helps a lot, because you can assess the motives on your opposite number much easier and much faster.
Well, Kara, I think we got the crowd going now. We have some questions coming in. Jamie asked, what payment provisions would you recommend for contractors when working as a subcontractor, if there's something that different they should do in that instance?
Well, again, I would start with going back to the payment timing provisions, which are getting heavily negotiated now. It will typically say, we'll pay you within 7 days of us getting paid. Why does it say that? Well, it says that because statutorily it's required. But it's important to follow that with a provision that says something like, and if payment takes more than 30 days, then payment will be due, 10 days after that. No matter what, you got to put some sort of deadline on there where you're defining reasonableness, because you've already been the bank for long enough. So now it's time for somebody else to be the bank.
That's great. I love it. Thank you so much for taking a question and a few questions and answering a question. That was so exciting to have a question come through the chat. Any other thoughts or last steps to avoid these payment problems before we move on? Everybody good? Awesome. I'm going to check the chat one more time. Okay, let's move on to the next one.
All right. Stories of success.
War stories.
I was going to say the warm fuzzies.
Well, if you win the war, you feel warm and fuzzy.
That's
right.
I think real life examples are always a great way, not only to make other people feel seen and heard, but to just give an example of how it can work out okay. You can walk through the fire and have all of these issues, but at the end of the day, it is okay because your business is protected. So we would love to hear some stories about some success stories that do maybe end in some warm fuzzies.
I think what the contracting community needs to understand is you have a tremendous toolbox of legal protections available to you if you just use them, or at least hire somebody who knows how to use them. And I'll give you, we've talked about the pay when paid, but I'll give you a couple of more examples. There is a series of statutes in this state called the Prompt Payment Act, which are, from the payor's viewpoint, incredibly draconian in the right circumstances. And what do I mean by that? If your upstream party has gotten paid and is withholding money from you without a good faith reason for doing that, in the absence of a good faith dispute, you take your typical interest due on that payment and you throw it out the window, and you get instead a statutory penalty of 2% per month plus your attorney's fees. And for those of you, and I hope there are not too many of you out there who are mathematically challenged, because that makes this business really hard to do, 2% per month is 24% per year. And believe me, if all of us were making 24% per year on our investments, we wouldn't be sitting here in this webinar. We'd be sitting on a beach drinking beer somewhere.
Yeah, I think that's a great example. Another thing, or another payment remedy that I see especially smaller contractors overlook on public projects is the payment bond. Almost, or every state project over $25,000, which is almost all of them in California, have a payment bond, is required to have a payment bond that's secured by the general contractor. Public federal projects all are required to have a payment bond if they're over $100,000. And what this bond does is it serves as security for all of the subcontractors and material suppliers, direct material suppliers on the project, if they're not being paid. And they can simply make a claim against this bond, but they need to protect their rights to make the payment bond claim, and then actually assert that claim. I'm shocked how many times I come across clients that are on a public works project and have these rights and haven't bothered to secure their claim in that way, which puts pressure on everybody because everybody gets notice of the claim. And I guess one kind of war story example of that was a matter that we had. I guess it was resolved early this year, and it was a project down in San Diego for the city of Chula Vista. And the client was a third-tier subcontractor, hadn't been paid in a year and a half, had sent a stop payment notice, but had never served preliminary notice. The stop payment notice was no good. And they were basically just being ignored. But we filed a complaint, and we figured out who the payment bond surety was, because they didn't even know who it was, named them in the complaint. As it turned out, in that situation, the statutes require that the direct contractor secure the payment bond. After the direct contractor does, a lot of times, if it's a multiple tiered project, that direct contractor will require its subcontractors also to secure payment bonds. But in this case, the direct contractor had not secured a payment bond. Instead, the direct contractor had relied on its subcontractors to secure payment bonds. That created a big problem for the direct contractor and for the city itself, because the city by statute is required to confirm that a payment bond has been secured. So we were able to assert a claim directly against the city for that. And in doing that, that created the pressure necessary for the direct contractor to come to the table when our third tier, the second tier subcontractor, which had hired our third tier subcontractor, had actually gone basically in the wind, disappeared, and run off with hundreds of thousands of dollars. So there wasn't anybody direct to go after, but luckily, because we were able to assert these claims, we were able to get the direct contractor to the table to settle the claim.
Yeah, Peter's absolutely right. Bonds, there are bonds on every public project. There are bonds on certain larger private projects. And anytime you've got a bond, you have a pressure point, because, and you may avoid litigation altogether, because you send in a notice to that surety. The way surety works is the contractor that's posted that bond has an indemnity agreement with its surety. And the first thing the surety is going to do when it gets a notice from you is call up its contractor client and say, how are you handling this? Because if I have to handle it on your behalf, you owe me. So it's a huge pressure point.
Right. We have another question that just came in from Joshua. Is it possible to add a mobilization clause to the contract order to receive payments to cover the first 30 days of work?
The answer to that is absolutely, and that's a great idea. You see that particularly on big jobs, but even on smaller jobs, in order to make it easier to get through that first 60 days. You see a lot of very vigilant contractors that will at least attempt to get a mobilization payment paid to them. And that's due either first day, or at the very least, it's due on the 30th day. So you're not hanging out until your 60th day.
Right. Yeah, I would absolutely agree. And what I would add to that is a mobilization clause can also be useful in negotiating change orders associated with multiple mobilizations. I've had a lot of clients that end up doing work on projects that get stopped in their tracks because of rain delays or RFIs or something that makes it that they can't complete their work. They have to demobilize and wait, basically. And a lot of them under the contract don't have any choice but to wait till they're instructed to remobilize. But a lot of times when they are instructed to come back, well, there are costs associated with mobilizing again for a second or third or fourth time. And if you have a mobilization clause that clearly spells out what the costs associated with mobilization are, it makes it much easier and gives you more leverage in negotiating a change order associated with multiple mobilizations.
Yeah, and even if you don't have a mobilization clause, temporary suspensions of work are classic claims scenarios where you should, even if you don't have that clause, you should still be asking for that extra money.
All right. Well, we're getting close to that 30-minute mark, but I wanted to make sure there's not any other questions out there or invite additional questions. I know that's why Peter and Peter are here today. So any questions out there by anyone that's watching this?
Yeah, take advantage. Take advantage of it, guys. You know, as my granddaddy used to say, if you think talk is cheap, speak with my attorney.
That's awesome.
Yeah.
Yeah. Well, if you do have questions and maybe you don't feel like throwing them in the chat right now, we also have something called our community here at Level Set, and you can ask questions through the community, and vetted attorneys and construction lawyers will gladly answer those questions. And on top of that, we're actually going to have an exclusive webinar, post-webinar conversation over on our community. Anyone that attended today will receive an email with the recording from this webinar, as well as a link to that exclusive conversation. So that is something fun you can choose to be a part of. Thank you guys so much for joining. This was great.
And I know there's people out there, and thank you, Kara. I know there's people out there that aren't from California. So if your question's in Texas or Florida or Wisconsin or wherever it is, just go ahead and post it there in the Expert Center, and you'll get a lawyer from one of those states to answer and give you some information and help you solve your payment problems. Why don't we go to the next slide? And just we'll do a quick introduction here to Legal Guard, and that's something exciting we have right now going on at Level Set. Legal Guard is the first legal plan specifically for the construction industry. Both Peter and Peter are members of it. It's something that you can talk to us about at Level Set. And this kind of, allows you and your company to get access to attorneys quicker, get some questions answered for free, and also get discounted legal services. So that's something you should really check out on our website about Level Set Legal Guard and learn how you can bring your business up. Because I think a lot of people think they don't need to call their attorney or have an attorney until there's a problem. But actually being proactive and letting an attorney read your contracts and read your agreements and understand and talk to you about the setup of your business is really going to help you in the future towards a more successful business. It's really part of it. So thanks everyone for coming out today. We really appreciate it. Payment help is here. And like we said, Kara has a great program afterwards to continue this in the Expert Center. And I know you're all getting emails now. So thanks a lot to Catherine, Peter, and Kara for putting this on. And I appreciate y'all allowing me to do this today. So thank you so much. And we look forward to more great webinars like this.
Thanks, everyone.
Thank you. Always good to see you, Seth.
Yeah, you too. Next time, I hope in person.
Yeah.
Bye-bye.
Bye-bye.